And our next speaker is Advocate Linda Retief. She is going to be talking surrogacy legalities. Linda Retief is a practicing advocate and member of the Pretoria Bar. Linda specializes in medical law and all peripheral legal issues pertaining to it, including the legal aspects of fertility and surrogacy. Her talk, Surrogacy Legalities, is a must for those considering this option.
A very good afternoon to all of you that have actually just tuned in. And I suppose if it's correct, what I already should have said is that you've clicked in to this virtual arena which we find ourselves in. I was very kindly introduced, so you've taken my thunder away, but I am an advocate by trade for the last 28 years. But actually, in truth, if I really think about it, what I'd like to impart is to tell you that first and foremost, I am a mother. And it seems odd that I would share that little bit of information with you. But the reason why I'm actually doing it is quite simple. I'm trying to explain to you that I also understand what it is to want to be a mother. I understand the incredible burn to want to be a parent. And more importantly, I also understand what it is like to have a fertility journey all of my own. So I'm hoping that in this virtual space that we find ourselves in presently, and for 15 minutes, that I'll be able to answer a number of questions which you have in your journey. Now, you'll notice during the course of my chat, I don't have a PowerPoint presentation. The election is actually personal, and the reason why I do it is that if none of you really understand or know, an attorney is actually always the voice of the client. And I've been the voice of a client for 28 years. So during this safe space, which I'm now going to refer to as the legal lounge, if I may, I want you to listen very carefully to my voice as I deal with the situation and the subject, and start packing elements in and questions in as we go in your surrogacy, we'll call it the backpack. The topic that I was given is surrogacy and legalities relating thereto. It is an incredible subject, and I'm very pleased it was given to me. If any of you out there are what we call pregnant infertile, I'm going to ask you not to push the pause button, because it would mean that this is the talk that you need to listen to. So what does pregnant infertility really mean? Well, it's for those of you out there who, number one, due to your anatomy, you're a male and you want to be an intended parent, and because of that, you don't have a womb. Well, let's say, secondly, you're a female and your anatomy allows you to have a womb, but your womb actually doesn't function. For some irreversible problem, you are unable to carry your baby right until full term, which is 9 months gestation. Or thirdly, you are a female. You don't have a womb, so in other words, you may have had a hysterectomy. Bottom line is, surrogacy then deals with the utilization of actually somebody else's womb. By introduction, the surrogate herself. Now, surrogacy, for a very good reason, is highly regulated in the Republic of South Africa, but it's condensed into one act or statute called the Children's Act. Now, the Children's Act is an incredible piece of legislation because it deals with the journey of a child's life, strangely enough, right from the very beginning, before the child was inceptualized, right up until minority ceases. Minority ceases, obviously, when the child becomes a major. Now, surrogacy forms only about 10, we call them sections within that, in the Act itself. But what I want to highlight here is that if you decide to follow the route of surrogacy, and the process that you elect does not form within that ambit of the Children's Act, it has dire consequences. So I need to labor a little bit on this point. The first thing is that if you've done it and you haven't ticked all the proverbial boxes within the Children's Act, the act or the process itself in law is unlawful. Any process in law that is unlawful has consequences sometimes, and in this case, that are rather dire. Dire in three ways. dire, first of all, for the surrogate mother. Because what happens now is that if the process is not legalized, the child that she births after 9 months, which is probably not her genetic material, in law becomes her child legally. It means she's seen as the mother, she is then seen as the legal guardian, and unfortunately she's seen to have all the responsibilities which she doesn't necessarily want at all on a child that she was just assisting a young intended couple to have. The second consequence is for the intended parents, and I'm going to highlight here mainly the intended mother, because what happens here is we've got parents whose genetic material is out there, but they don't have any legal right to them. They don't have rights, and they don't have responsibilities, and there's no guardianship over your own genetic material. The third issue is that it's for the child itself. So if it's not legal, then a child is born into an environment where its genetic parents are not in law seen as its parents. It has a legal guardian who's not connected to it in any way at all. And if we consider what the main purpose of the Children's Act is, in other words, the best interest of a child, it would mean that that child has been born into a household which is not in its best interest. So if we just pause there for a minute and we realize those consequences are not really why you want to come on this journey. You're embarking on this journey because you want a child of your own. Let's look at the legalities themselves. Now, although there's only 10 provisions in the Children's Act that relate to legality, I like to make things simple. It's the only way that one actually convinces even a court of law. So let me convince you. There's only 2 proverbial steps that you really need to take in law to make your process legitimate, or to legitimize your process. So I'm going to deal and I'm going to highlight those 2 points. But at the same time, I'm also going to highlight, time permitting, there's a number of provisions in the Act which I think you need to write down and be very, very careful and consider it and reflect when I'm finished my talk. Right, back to the steps. So the 2 steps really that you need to legalize this process that you've decided to embark on is that you're going to need a team before you embark on it. 2 teams. First team is going to be yourself. You are the intended parents. And that can be, parents can be single, they can be married, they could be lifelong partners, they can be in a heterosexual relationship, they can be in a same-sex relationship, it really doesn't matter. But you want to be a parent, so intended parent. And in that camp is going to be your surrogate mother. A word of warning, be very cautious, be very careful, and elect her well, because she's going to be carrying your genetic material. So that's camp number 1. In camp number 2 on this side, when you embark on your legality journey, is you're going to have your legal team. Your legal team is going to be made up of an attorney, and it's going to be made up of an advocate like myself, the voice ultimately in court, and it's going to be the court itself, a judge, not a magistrate's court, but only a high court. Simply put, when we're dealing with status issues and with children, and that's what we're trying to change, is status issues with surrogacy, it's only a high court that can declare and pronounce the outcome that you really want. So camp 1 is the parties, camp 2 is the legal team. The first step that you're going to require is all the parties in camp 1 are going to have to conclude a written surrogate motherhood agreement. Now, this is not what I call willy-nilly. This agreement is possibly one of the most important agreements that you will sign in your journey going forward. The agreement itself, first of all, it ticks off the legal pre-emptory provision that you have. In other words, it blows life into legality of what you've decided to do. The other thing is that this agreement is going to be utilized to regulate the relationship between you from the subsistence of your relationship with your surrogate mother all the way until the birth. So it's going to regulate what happens in more than a 9-month period, because sometimes the artificial fertilization is not successful the first time, and you're going to need more time or a further implantation. So this relationship has to be regulated in writing. The third important thing about the agreement is that without that, and we'll deal with the second step now, the legal fraternity who you've been hearing about for the last couple of hours before me are not authorized at all to start any artificial fertilization procedures whatsoever without the conclusion of this written agreement, but more importantly for the step 2, which I'm now going to discuss, of your legality requirement. So step 1 is you've got your agreement, you've signed it, and you're happy. You then take that agreement and you take it to the foot of the High Court. And what the Act says is that a court of law must now confirm this agreement. Now, confirming really simply means that a judge will have a look at this agreement and make sure that the provisions in the agreement are sound if you compare that to the provisions of the Act. And that's why in Camp 2 you have an attorney. It will be an advocate that you're going to have at your side to explain to the judge that the agreement is sound in every respect. And if the court decides to confirm that agreement, a number of wonderful things happen at that very moment. The first thing that happens is that you get that absolute peace that should the process be successful and the surrogate mother births a child, that child is declared yours in law, notwithstanding the fact that the child has been birthed from her womb. So that you've got to have in hand. Plus, you take that order to your medical practitioner and you say to him or her, you're now authorized in law. Let's commence with the procedures of artificial fertilization. Although the confirmation is as important as I've said, it does have a lifespan, so be mindful of that. The lifespan of this order is a mere 18 months. 18 months sounds like a very long period, but when we're dealing with procedures like we're dealing, and with human bodies, and the surrogate may not have fallen pregnant with the first set of procedures, 18 months is a very, very short time. After the fluctuation of 18 months and she hasn't fallen pregnant, you're going to have to begin the procedure again at the foot of the courts. So that's very simply put. That's what happens. So those are the 2 simple steps, and now you have the law behind you to commence with your journey. Now the time is ticking away, but there are a number of provisions I quickly want to mention. The one important point to mention is, we call this the genetic link in surrogacy. Bottom line is that there must be a genetic link between one or both of the intended parents with the infant. So people who are pregnant infertile but find themselves in a difficult position that they're not fertile themselves, both of them, unfortunately, the surrogacy journey ends here for you. The only option that you'll have in law would then be to adopt. But if only one of you is infertile, it would mean that you are entitled to utilize the gamete, either if it's an ova or a sperm from somebody else, provided that the child or the embryo that is formed at least has one genetic link to you. So that's the genetic link. It often happens that the surrogate mother performs 2 functions in law. She decides to give of her egg because it might be just easier that way than finding a donor. And she also has the prospect of utilization of her womb. Now, if those 2 scenarios are present, be warned, young intended parents, that she has a window period. I always refer to it as a cooling period, and perhaps that's not the right thing to do. But once the child is born, she has 6 months to decide whether or not she is willing to give this child up. And if she decides otherwise, it could be that the journey has ended for the intended mother at this particular point. Lastly, as a last bit of comfort, surrogates are not entitled to be paid for their services at all in law, other than what the Act provides. So it's unfortunately not what we call a womb for hire, and it's extremely important that the legal team as well as the Camp 1, i.e. the parties in the agreement realize that no monetary value in terms of a financial reward can be paid in any respect to a surrogate. Lastly, a little bit of comfort, and simply is that whatever journey you have in court, it is privileged, even though the court itself is a public arena. Thank you very much.
For those of you that don't know, Linda and I have worked extensively over 20 years in this field, and we have quite a few questions. So
Sure.
Those that we can't get through now, we will probably send to you afterwards.
100%.
So I think it's very important also to state that 20 years back, we didn't have the benefits of surrogacy motherhood agreements.
That's right.
And I think it's 2010 that all of these changes came about that made it more, like you said, gave us more peace of mind.
A structure. Gave us a structure. Yeah.
Okay.
Yeah.
So first question that comes up is from Anonymous saying, how do I know if surrogacy is for me? And I think she's asking in terms of the law, that it's not just anyone who doesn't want to fall pregnant or wants to design a baby. So what does the law state in terms of that?
So you'll know it's for you if two things are apparent, legally speaking now. The first thing is that you've realized that the womb that you have or don't have is not going to carry a child till full term. And the condition that you have, if you have a womb, is irreversible. So nothing medically they can do can help it. So you're going to have to utilize somebody else's womb. And it's actually a pleasure, and it's actually quite exciting that that opportunity arises. If you decide that that is the journey you want to take, the second thing consideration is for Miss or Mr. Anonymous, is that if you're a single person, you must be fertile. They must be able to harvest either your sperm or either your egg. If you're in a loving relationship, at least one of you should be fertile. So that's really, then you're going to know that this is for me, because I want a child that has my genetic link, and adoption can then be placed on the Bunsen burner, so to speak.
Yes, so it's not as simple as going to the doctor and saying, I want a surrogate mother.
No.
And, okay.
No.
Somebody who's asking the difference between gestational and traditional surrogacy, which I know is a question we often get.
Yeah. All right, so traditional surrogacy is the first point. In other words, where you're utilizing the womb of somebody else. So unfortunately, not somebody else, but the egg of the intended mother, sorry. So it would mean then that you are either going to utilize the egg of the intended mother or a donor, but not the surrogate. I think that's a clearer way of putting it. The reverse is that, as I ended the talk off, that it happens sometimes where the surrogate mother herself decides, depending on the situation or the relationship between the people, that she would want to utilize her egg, and the intended parents are quite happy. She then becomes gestational. It becomes her egg and her womb. That's the difference, because normally it's not. It's just the womb and not her genetic material.
And I think what's important to say to Anonymous is that when it is a traditional surrogacy, that there is still that cooling off period.
Correct.
So it's often a more challenging road to take.
Correct.
Okay. And then a lot of people are asking, how do we stop the surrogate mother from exploiting intended parents? And I think this is where you and I work together. It's that's where we need the help of psychologists.
Yes. It's a very difficult question, because what happens is we call this in law lip service. So lip service normally means that the surrogate understands up front, she signs an agreement that she's not going to receive money for it, and she's quite happy, and then the process, and that is what they tell the court, and the court is happy on the papers that indeed is the intention behind it all. But as time goes on and frustrations rise, you do get circumstances where the surrogate decides that she wants to be paid for that. Well, first and foremost, there is an agreement, a legal contractual agreement between the parties, which unfortunately she has to honor. So any dispute that happens between the parties, there is a breach of that agreement. I always then say that together with a psychologist like yourself, the parties must seek mediation to get to that point, because the end result is dire for all the parties and has a legal consequence, one which I doubt that they actually want to even go there or endure. So it becomes a field that you have to sort out immediately.
And like we're both concluding, mediation during surrogacy is extremely important. I mean, we've got a black and white contract, but we're dealing with people's hearts here. So it's very important to actually mediate throughout the journey.
Correct.
Including closure at the end.
Yeah, you know, Mandy, the process of fertility is personal. It's private. Mediation allows that in the sense that it's confidential. It allows the parties themselves to actually make the decision and decide how they're going to deal with it. They might want to amend their agreement in some way, but they certainly can't contract into an unlawful agreement.
Thank you, Linda.
Pleasure,
Always a
Mandy.
wonderful pleasure talking to you.
Absolute pleasure. Thank you so much.
Thank you very much.